Trump's defense didn't just stumble, it exploded in real time. 3 critical witnesses, once positioned as the backbone of a civil fraud defense, have flat-out refused to testify. Moments later, his own legal team walked out of the Manhattan courthouse, signaling what insiders are calling a total internal collapse. This wasn't a clever delay or courtroom chess move. It was a full-scale implosion triggered by a leaked internal memo so devastating that even Trump's most loyal attorneys couldn't justify staying. When lawyers abandon their client mid-hearing, you're not watching strategy, you're witnessing a detonation. Hit that subscribe button now, because what's unfolding next is unlike anything we've seen before. So what caused this unprecedented meltdown? A confidential defense strategy document, mistakenly filed with the court on December 27th, blew the case wide open. Legal analysts say the memo outlines plans for manufactured testimony, including coaching 3 witnesses to deliver statements that directly contradict evidence already admitted by the court. This crossed a red line. Multiple sources say members of Trump's own legal team chose to flee rather than risk disciplinary action, or worse, for what could be interpreted as orchestrating perjury. When defense attorneys start protecting their bar licenses over their client, the situation has officially gone nuclear. Here's how everything unraveled. 4 weeks, Trump's defense team had been cracking under pressure, clashing over strategy, drowning in mounting evidence, and repeatedly butting heads with Judge Arthur Engoron. Insiders describe explosive internal meetings, with senior partners locked in bitter debates over whether to attack hard evidence head-on or attempt to explain it away through carefully scripted testimony. The tension reached a boiling point on December 23rd at Morrison's Park Avenue offices, where junior associates reportedly warned that witness preparation was heading into dangerous territory. The argument became so intense that 2 associates threatened to quit the case outright unless the strategy changed. Morrison allegedly brushed them off, insisting that real advocacy meant pushing limits that cautious lawyers wouldn't understand. That same night, the memo that would ultimately torpedo the defense was written. Then came December 27th, and total disaster. Attorney Sarah Mitchell accidentally filed a 47-page internal strategy memo instead of a routine procedural motion. Court clerks immediately flagged it when they realized it wasn't legal argumentation at all, but a detailed blueprint for witness coaching. Stamped attorney work product, confidential, the document laid out explicit plans to align testimony in ways that directly conflicted with bank records, property valuations, and loan documents already in evidence. The most explosive section, labeled Witness Preparation Protocol, spelled out tailored talking points for each witness, designed to undercut the prosecution's case piece by piece. Collins was instructed to claim sudden memory lapses about property valuations he personally approved. Brennan was coached to reframe finalized assessments as preliminary estimates, despite email trails proving final authority. Rodriguez was directed to portray signed loan documents as casual conversations rather than binding agreements. This wasn't aggressive lawyering. This wasn't creative defense. This was something far more dangerous, and the legal team knew it. And that's why they ran. This wasn't just aggressive lawyering anymore. Legal experts say the strategy crossed a bright, ethical red line, straight into potential perjury orchestration. Smash that like button if this is clicking so far, because this is where everything turns deadly serious. When Judge Arthur Engoron reviewed the accidentally filed memo during a closed-door chamber session, sources say he immediately understood this wasn't something that could be brushed aside or explained away. And let's be clear, mass witness refusals combined with attorney withdrawals almost never happen. Not over pressure, not over disagreements. They happen when lawyers believe they're being pushed toward actions that could end their careers. Here's what multiple courthouse sources say unfolded next. On December 28th, lead defense attorney Christopher Morrison urgently requested an emergency conference with Judge Engoron after 3 key witnesses scheduled to testify that week submitted written refusals to appear. Those witnesses weren't minor figures. They included former Trump Organization CFO Jeffrey Collins, property assessor Michael Brennan, and banking executive Lisa Rodriguez. According to sources cited by CNN, Morrison's voice was visibly shaking as he informed the court that his own witnesses were refusing to take the stand. Collins, who was set to testify about property valuations on December 29th, sent a stunning early morning email to the defense team at 6:47 a.m. In it, he flatly refused to appear unless granted immunity from potential perjury charges. The message reportedly read, "After reviewing materials provided for testimony preparation, I cannot in good conscience provide statements that contradict documentary evidence in my possession." Legal analysts say refusals like this, especially from former top executives, are almost unheard of. Loyalty usually holds. Fear the severe does not. Then came Brennan, and his refusal hit even harder. As the independent assessor responsible for valuing multiple Trump properties, his testimony was central to the defense's fraud challenge. His attorney, Margaret Sullivan, submitted a formal letter to the court stating that Brennan would not testify in a manner that contradicted his professional work product or documented assessments. The letter included a sharp reference to recent developments in case preparation that made truthful testimony impossible. In legal terms, that's a nuclear warning flare. Rodriguez's withdrawal sealed the collapse. Banking executives almost never walk away from testimony in high-profile trials. Institutions normally provide ironclad legal backing and media shielding. But sources say Rodriguez hired independent counsel after reviewing the witness preparation materials and concluded that testifying as instructed would violate her professional obligations and potentially federal banking regulations. At that point, the defense wasn't leaking, it was hemorrhaging. Inside the courtroom, the breakdown became visible. Junior Associate Rebecca Chun was seen hurriedly removing boxes of documents from the defense table while the hearing was still ongoing. Court observers described a chaotic scene, with Chun making repeated trips into the hallway as Morrison struggled to address the judge. By noon, Morrison formally requested immediate withdrawal from the case, citing irreconcilable differences over litigation strategy. The withdrawal motion shocked even veteran court watchers. Its language was unusually blunt, stating that continued representation would violate professional conduct rules and could expose attorneys to sanctions. Reporters who reviewed the filing noted a chilling conclusion: the attorney-client relationship had been fundamentally compromised by ethical conflicts that could not be reconciled. In other words, the defense didn't just fall apart. It collapsed under the weight of its own strategy. Those directives on witness preparation were the final line, and according to legal ethics experts, they obliterated it. Professor Michael Davidson of Forum Law School told reporters he had never seen language this explicit in an attorney withdrawal motion, calling it a rare public admission that a client demanded conduct lawyers simply could not ethically perform. Drop a comment right now if you saw this coming. I read every single one. Because what happened next sent this case into free fall. At exactly 2:47 p.m., Christopher Morrison stood to address the court. Reporters noted his hands were visibly trembling as he gripped the withdrawal motion. "Your Honor," Morrison began, clearing his throat, his voice cracking, "I can no longer, in good conscience, continue this representation." Judge Arthur Engeron leaned forward, his expression instantly hardening. "Are you telling this court that ethical issues prevent you from continuing?" he asked. Morrison barely looked up. "Yes, Your Honor. I cannot participate in the strategy outlined in the document inadvertently filed yesterday." The courtroom went dead silent. Veteran reporters later said it was one of the most chilling moments they'd witnessed in decades of courtroom coverage. That was the instant it became undeniable. This wasn't a routine attorney-client dispute. This was a breaking point. Trump's own legal team had concluded that following his directives could cost them their licenses, and potentially far more. When lawyers choose self-preservation over loyalty, it's because the danger is real. The shockwaves rippled instantly through Manhattan's legal community. A lead attorney publicly severing ties with a high-profile client over ethics sends one unmistakable signal: the evidence is so toxic that defending it is more dangerous than walking away. Claims of prosecutorial overreach evaporate the moment your own defense team refuses to keep fighting. You don't abandon ship unless the hull is already breached. History gives us chilling parallels. During Watergate's infamous Saturday Night Massacre, Attorney General Elliot Richardson resigned rather than carry out President Nixon's order to fire Special Prosecutor Archibald Cox. Deputy Attorney General William Ruckelshaus followed him out the door, choosing professional integrity over presidential pressure. Their resignations weren't political theater, they were survival decisions. The same pattern emerged during the Enron collapse. When Arthur Andersen auditors realized they were being pulled into financial misrepresentation, many fled rather than risk professional annihilation. The firm itself disintegrated within months as careers were saved by walking away. More recently, during the Theranos fraud trial, multiple attorneys withdrew from representing Elizabeth Holmes once they understood the scope of the allegedly false claims they were being asked to defend. Legal ethics professor Janet Morrison of Georgetown Law summed it up bluntly: mass withdrawals only happen when attorneys believe continued representation could turn them from advocates into co-conspirators. The critical difference here? In those cases, lawyers had time, weeks or months, to quietly step aside. This time, an accidentally filed memo forced an immediate reckoning. No spin, no damage control, no graceful exits. And this wasn't happening in isolation. Trump's legal orbit has been shedding attorneys for years, and the warning signs were already there. During the classified documents investigation, multiple lawyers quietly withdrew after encountering what they described as obstruction of their own fact-finding efforts. In May 2023, attorney Tim Parlator exited the team, citing internal conflicts that made effective representation impossible. Jim Trusty followed soon after, with sources pointing to deep fractures over strategy and client cooperation. Even by white-collar defense standards, the turnover was extraordinary. In fact, legal recruitment firm Major, Lindsay in Africa reported that Trump-related cases have seen attorney departure rates nearly 300% higher than comparable high-stakes litigation. And the reason wasn't money. It wasn't workload. It was ethics. Strategy clashes. Lines lawyers refused to cross. But what's happening now is different and far more alarming. This time, attorneys are fleeing mid-proceeding, not during quiet preparation phases. And they're running not because of suspicions, but because a strategy document accidentally dragged everything into the open. The pattern couldn't be clearer. When legal professionals believe they're being pushed toward actions that threaten their licenses and potentially their freedom, loyalty evaporates. Survival takes over. So what, exactly, triggered this unprecedented legal exodus? According to multiple legal ethics experts who reviewed the accidentally filed memo, the defense strategy violated some of the most basic rules of professional conduct. The document reportedly laid out detailed plans to prepare witnesses to deliver testimony that directly contradicted documentary evidence already in the record. Collins was allegedly instructed to deny knowledge of property valuations, even though his own emails showed he personally reviewed and approved them. Brennan was reportedly coached to portray himself as independent, despite internal Trump Organization documents showing direct supervision of his assessment work. But here's the part that sent legal experts into full alarm mode. The memo allegedly included explicit instructions to avoid creating written records of witness preparation sessions and to conduct coaching meetings outside traditional legal environments to minimize any paper trail. That's not zealous advocacy. That's not aggressive defense. Experts say that's drifting straight into witness tampering and evidence obstruction territory. And that's why this matters far beyond one courtroom. If attorneys can coordinate testimony to contradict documented facts without consequences, the entire adversarial legal system collapses into performance art. Evidence becomes optional. Truth becomes negotiable. Trials turn into scripted theater where reality takes a back seat to coaching. This leaves Trump's remaining legal team trapped in an impossible position. On one side, they face relentless pressure from their client to go on offense, attack the prosecution, discredit evidence, frame everything as political persecution, and fight with maximum aggression. On the other, they're staring down a mountain of documented evidence and a leaked strategy memo, so toxic that their own colleagues walked away rather than touch it. And that's where the story is headed next, because once attorneys start choosing the exit over the argument, the case stops being about defense strategy and starts being about damage control. Destructive. The fallout doesn't stop at trial court. Trump's remaining lawyers now face the impossible task of explaining to appellate courts how the defense disintegrated so completely that its own witnesses refused to testify, and its lead counsel walked out in the middle of proceedings. That's not just embarrassing. It's legally radioactive. And here's the trap: there is no clean explanation. Either the accidentally filed memo accurately reflected the defense strategy, in which case the ethical violations are glaring, or it was somehow a fabricated document that entered the official court record bearing the letterhead and signature of Trump's lead attorney. Both possibilities are catastrophic. Legal and constitutional scholars are calling this an unprecedented breakdown of the attorney-client relationship in a major civil case. Columbia law professor Sarah Martinez told the New York Times that mass witness refusals, paired with attorney withdrawals mid-trial, represent a level of defense collapse almost never seen in high-stakes litigation. She explained that when lawyers conclude continued representation would violate professional conduct rules, the underlying strategy has almost certainly crossed bright ethical lines. Martinez also warned that the accidentally filed memo now exists as a permanent court record, one that could be cited in future disciplinary proceedings against any attorney connected to the plan. Georgetown law professor David Walsh echoed that concern in comments to CNN, calling the situation a perfect storm, where documented strategy collides with professional responsibility in a way that cannot be undone. Walsh noted that the memo's detailed instructions for coordinating witness testimony could trigger bar investigations regardless of whether the strategy was ever fully executed. In other words, intent alone may be enough. Even conservative legal analyst Jonathan Ter extend the trial by at least 3 months, pushing any final resolution squarely into the heart of the 2024 election cycle. That delay alone hands enormous leverage to the prosecution, led by New York Attorney General Letitia James. Any replacement defense team would be forced to start from zero, digesting thousands of pages of evidence that already convinced the previous lawyers that continuing representation posed ethical landmines. In legal terms, that's not just a setback. It's a structural disadvantage that can't be fixed with time or talent. But the damage doesn't stop in that courtroom. The reputational fallout is spreading fast, and it's brutal. When 3 key witnesses refuse to testify and attorneys abandon a case citing ethics, it sends a chilling message to the entire legal industry. Representing Trump may come with career-ending risk. Multiple white shoe Manhattan firms have reportedly declined new Trump-related matters outright. Sources at 3 major firms told legal publications that partnership committees have implemented new screening requirements for any potential Trump representation, including mandatory ethics committee approval and expanded malpractice insurance coverage. That's not routine. That's defensive lawyering at the institutional level. The result is simple and devastating. The pool of qualified, experienced attorneys willing to take Trump cases is shrinking fast. And when elite firms won't touch a case, it's not because of politics. It's because the professional downside has become impossible to ignore. Then there's the broader legal fallout, and this is where it gets truly staggering. The collapse of this defense hands prosecutors in Trump's criminal cases something extraordinarily valuable: documented evidence of intent. The accidentally filed strategy memo now sits as potential evidence in any future obstruction or witness tampering investigation. It doesn't matter whether the strategy was fully carried out. Legal experts say the memo alone could be used to demonstrate a pattern, an attempt to coordinate testimony that directly contradicts documentary evidence. Drop a comment with your thoughts. I genuinely want to hear your perspective, because this goes far beyond one defendant or one trial. This cuts to the core of how our legal system functions. The attorney-client relationship is foundational. It's built on zealous advocacy bounded by ethical limits. That balance is what allows even the most controversial defendants to receive fair representation while preserving the integrity of the courts. If attorneys can coordinate witness testimony to contradict hard evidence without consequence, the adversarial system collapses. Trials become theater. Facts become optional. That's why panic is now spreading through Trump's remaining legal network. Reports indicate senior attorneys held emergency video conferences throughout the weekend, urgently assessing their own exposure and debating next steps. Sources familiar with those calls describe heated arguments over whether other Trump legal teams might be sitting on similar strategy documents that could surface just as explosively. Law firm risk committees are reportedly conducting emergency audits of all Trump-related files, searching for any potential ethical vulnerabilities. One faction pushed for aggressive damage control, arguing the memo was taken out of context and portraying the attorney departures as routine strategic disagreements. This group, led by lawyers still representing Trump in other matters, advocated a unified narrative framing the crisis as prosecutorial intimidation and judicial bias aimed at crippling Trump's defense. The other faction wasn't buying it. They argued the ethical implications were too severe to ignore, and that any association with coordinated witness strategies could invite bar sanctions, criminal referrals, and irreversible professional ruin. Their position was blunt. No client, no matter how powerful, is worth losing your license or your freedom. And that's where the legal community now stands, fracturing in real time, caught between loyalty to a client and the most basic rule of the profession: don't cross the line. Professional survival. The shockwaves reached the broader legal establishment almost immediately. The Association of Criminal Defense Lawyers reportedly convened an emergency board meeting to debate whether formal guidance should be issued on ethical obligations in politically charged, high-profile cases. Sources say the discussion turned heated fast. Some members argued that political prosecutions demand unusually aggressive advocacy. Others pushed back hard, insisting that professional conduct rules don't bend, no matter how political the case or how powerful the client. At the same time, Trump's core supporters erupted in fury at the attorneys who walked away. Social media platforms were flooded with attacks on Morrison and his team, branding them deep state operatives, cowards, and traitors who abandoned Trump at his most critical moment. They were accused of folding under judicial intimidation and political pressure. Conservative legal commentator Mark Levin called the withdrawals a coordinated assault on zealous advocacy and demanded investigations into prosecutors for allegedly pressuring defense counsel to abandon their constitutional obligations. Tucker Carlson devoted an entire segment to blasting what he called weak lawyers who buckled under pressure from the legal establishment, framing the exits as proof that even Trump's own attorneys couldn't be trusted to fight what the base views as judicial persecution. The backlash quickly turned dangerous. Right-wing social media accounts began circulating personal information about Morrison and Rebecca Chun, with some users calling for protests outside their law offices. According to sources, the attorneys hired private security after receiving threatening messages accusing them of betraying Trump. Legal ethics experts warned that targeting lawyers for ethical decisions sets a chilling precedent, one that could intimidate future attorneys from upholding professional standards in politically explosive cases. Then Trump himself escalated the situation. In a series of posts on Truth Social, he lashed out at the attorneys who withdrew, calling them weak, disloyal, and incapable of standing up to judicial pressure. He claimed the accidentally filed memo was deliberately leaked by dishonest lawyers working with prosecutors to sabotage his defense. The post specifically named Morrison and Chun, labeling them incompetent sellouts who would pay a professional price for abandoning him during a critical phase of the case. Stay with me, because this is where everything changes. Trump's response did something extraordinary. Instead of denying the authenticity of the memo or disputing its contents, his reaction was aimed entirely at the lawyers who refused to carry out the strategy it described. Legal experts immediately noticed the implication. When the response to alleged ethical violations is to attack the people who expose them, rather than deny the conduct itself, you're no longer arguing innocence. You're confirming the conflict. Professor David Chin of NYU Law told CNN that publicly attacking former attorneys for raising ethical concerns, while sidestepping the underlying behavior, can itself become evidence of intent to pressure legal representatives into violating professional rules. Chin warned that this posture only reinforces the severity of whatever ethical issues convinced experienced litigators to abandon a high-profile case in the middle of trial. And that's why the story goes far beyond one defendant or one courtroom. The real question now is whether clients, especially powerful, politically charged ones, can push lawyers to orchestrate testimony that contradicts documented evidence without facing meaningful consequences. If attempts to coordinate false or misleading testimony carry no professional or legal repercussions, then the rule-based structure of the legal system collapses. At that point, advocacy doesn't just cross the line, it erases it. If this stands, the legal system's reliance on honest advocacy collapses into pure theater, where documented facts are forced to compete with coached performances. If that realization hits you, smash the like button right now. Because here's the reality. 3 key defense witnesses have refused to testify, And Trump's lead legal team has walked away from his civil fraud case after accidentally filing a strategy memo that allegedly outlined plans to present testimony contradicting hard evidence already in the record. This moment is being watched far beyond one courtroom. Legal professionals nationwide are quietly reassessing their Trump representation agreements, weighing whether continuing these cases exposes them to unacceptable professional risk. When experienced defense attorneys publicly break with a high-profile client in the middle of active proceedings, citing ethics, we are in genuinely uncharted territory in American legal history. If there are no consequences for attempting to coordinate witness testimony that contradicts documented evidence, then professional conduct rules become optional when the stakes are high enough. At that point, the attorney-client relationship stops being a safeguard of justice and becomes a mechanism for evidence manipulation. That's not advocacy. That's system failure. Now all eyes turn to Judge Arthur Engoron. He must decide whether to grant continuance requests that could delay proceedings for months, or force the case forward with a visibly weakened defense. Meanwhile, prosecutors in Trump's criminal cases are reportedly scrutinizing the accidentally filed memo for patterns consistent with witness tampering or obstruction. Legal ethics committees across the country are watching closely to see whether professional standards will be enforced when political pressure collides with ethical duty. Before we go any further, hit that subscribe button, because stories like this don't end quietly. Here's where things stand right now. 3 defense witnesses have refused to testify. Trump's lead legal team has abandoned the case, stating plainly that ethical obligations made continued representation impossible. A strategy memo outlining coordinated testimony now sits permanently in court records. And the legal community is waiting to see which force ultimately prevails, client pressure or professional responsibility. This isn't a temporary headline. It's a real-time stress test of the legal profession itself. The collapse has happened publicly. The evidence is documented. The ethical lines are no longer theoretical, they're written into the record. What happens next will determine whether professional accountability still means something in high-stakes litigation, or whether power and pressure can override ethics without consequence. The integrity of the legal profession is on the line. The promise of equal justice under the law is being tested in real time. Pause for a moment and hit that like button if you understand just how serious this really is.